Hello, good afternoon, guys. Wonderful afternoon. I hope you guys had a great weekend. Today, we're going to be talking about when to file your removal of conditions as a green card holder. Welcome. If you watch this live video later, you're very welcome. As usual, we're spilling the legal tea. So just be here and enjoy this video. All right, guys. So let's jump right into it. Let me share my screen with you. And let's get started right here. Okay, so when we talk about removal of conditions, this is also, of course, for green card holders. And we're going to be looking at this from the point of view of marriage. If you are married less than 2 years before the approval of your first green card, you are given a green card known as a conditional green card. And the conditional green card, 90 days before the expiration of the green card, you need to file to remove the conditions. It's all in a bid to show to the U.S. government that you did not get married just to procure U.S. immigration benefits. So we're going to be discussing the timelines because there are exceptions. Sometimes you may need to file the removal of conditions within the 90-day period before the expiration of your conditional green card. Other times you could file before, during, or after that 90-day period. Okay, so let's take a look at the shared documents. Welcome, guys. Drop me some comments and I will be reading them very soon. So if you were granted conditional residence through marriage to a U.S. citizen or a green card holder, so the form you use is the I-751 and you need to petition to remove the conditions on residence. Okay. And okay, so if you have dependent children who acquired conditional residence status on the same day as you or within 90 days thereafter, then include their names. Of course, you have to include their names on this form. And okay, so let's see here. It says yeah, in order to request that the conditions on their status be removed as well. Okay, so if you have dependent children who did not acquire conditional residence status on the same day as you or within 90 days thereafter, or if the conditional resident parent is deceased, then those dependent children must each file Form I-751 separately to have the conditions on their status removed. So that's not going to be our focus in today's video. We're going to be focusing on this. So if you are still married, then file the I-751 jointly. So here's the point. If at the end of the 2-year period, well, 90 days before the 2-year period comes up, you are still married, you need to file what's known as the joint application. So you're going to file jointly with your spouse. And what you're going to be doing is to petition the U.S. government or the U.S.A to remove the conditions from your green card. So you file jointly with your spouse, and the spouse must be the same one through whom you obtained the conditional status. So it doesn't work to have been married to a U.S. citizen who is known as maybe Peter, and then after 1 year you hop on to John and then try to remove conditions through John. No, you have to file through Peter, okay? Peter or Peter. Yes, so you have to file through Peter because he's the one who granted, who filed for you to obtain your first and initial green card. So it has to be through the same spouse. That's number one. And then there are some conditions where you will be granted what's known as a waiver. And what that means is that you're filing an I-751 waiver. You're not filing jointly with your spouse. And there are 5 conditions. So the first one is when you enter the marriage, let's say you enter the marriage with Peter in 2019, you were given a green card, conditional, because of course let's say the approval came in 2020. You had been married less than 2 years before the approval came. And then unfortunately, Peter dies let's say after getting your conditional green card, he dies a few months later. Of course, you cannot file a joint petition because Peter is dead. So what you need to do now is to file an I-751 waiver Okay, so this waiver is telling them that, hey, I know I'm supposed to be filing jointly with my spouse, but can you excuse me? Can you exempt me from this joint filing? Okay, so you enter the marriage in good faith, but your spouse subsequently died. That's the first condition. Secondly, you enter the marriage in good faith, but the marriage was later terminated or ended due to divorce or annulment. So you got married in good faith. It means that you didn't get married just to procure U.S. immigration benefits or just to get a green card. It wasn't a green card marriage. You did get married validly, but the marriage later ended in divorce or annulment. So maybe there was some, incompatibility issues. Maybe the sex, you guys were not compatible sexually. Maybe you were not compatible religiously. You found out suddenly that, hey, you were not compatible in terms of even how you raise children, your beliefs. Somebody believes that, hey, I should spank the child. The other person says no. So perhaps that's what broke up the marriage. So you need to still be able to establish, even though you're filing the waiver, that, hey, the marriage was a good faith or a bona fide marriage. Then the third one is you enter the marriage in good faith, but you have been battered or subject to extreme cruelty by your petitioning spouse. So here, you don't need to have been divorced. You could be still in the marriage, but you are being subject to, crazy treatment, extreme cruelty. That's the standard. It must meet the standard of, battery or extreme cruelty by your petitioning spouse. And so clearly you will not be able to file a joint petition with somebody who's beating you and has turned you into a punching bag. And I mean, this logically makes sense. So in that instance, you need to, file the waiver and say, hey, I will not be able to file with my spouse. And the basis is that he's, he punches my stomach even though I'm pregnant, or boots me, or kicks me, or bites me, or whatever. Okay, or it can be battery or extreme cruelty. So maybe he's not even touching you, but just subjecting you to extreme cruelty. Some people would go and give birth, and immediately they come home, the husbands want to demand sex from them every night, about 3 times a night, even though they just gave birth, delivered, maybe through C-section or vaginally. I mean, that is extreme cruelty. The woman is vulnerable at that point. So things like that. Or he knows that you're a foreigner and you don't have a job, and he refuses to buy groceries, and so you're hungry. Sometimes you go 3 days and you just drink hot water. Things like that are extreme cruelty. Okay, so just be ready to prove to them that, hey, I married in good faith, but he is killing me in this marriage. Then the fourth is that your conditional resident parents entered the marriage in good faith, but you have been battered or subject to extreme cruelty by your parents' U.S. citizen spouse, or lawful permanent residents. Okay, so this is for the children who have conditional residence based on their parents' marriage to U.S. citizens or green card holders. Then the last condition is that the termination of your status or removal from the United States would result in extreme hardship. Okay, so in this instance, you can also file a waiver. You don't have to file a joint petition with your spouse. All right, guys. Okay, so let's move on to when the timelines of the I-751. So normally, if you're filing jointly, you need to file the petition with your spouse, of course, 90 days, as I keep telling you, immediately before the green card expires. And so if your green card is set to expire, let's say May 30, 2021, that's a 2-year green card. You need to calculate 90 days before that date. And so let's say March, April, and May. So let's say March has 31 days, April has 30 days, May has 30 days. So from about March 1st, you need to apply if your card is going to expire on May 30th, because it's 90 days. So you have the window between, so you have to apply between March 1st and May 30th. Okay, so during that timeline is the 90-day period before the expiration. So that's when you need to file. And then when you are doing, let's say here, filing with a request that the joint filing requirement be waived or individually filed. So when it comes to the waiver or the exemption from the joint filing, you have more options. It's less restricting in terms of the time frame. And so you may file the I-751 without your spouse if they're deceased, you're divorced, or you and your conditional resident child were battered or subject to extreme cruelty. Then you may file the petition at any time after you are granted conditional resident status and before you are removed from the United States. So guys, note this. If you allow your conditional card to expire without refiling or without removing the conditions, you may be issued with an NTA, notice to appear. That means that you have been put in deportation proceedings. Deportation proceedings have been commenced against you. So before you are removed from the United States, that's when you should file. You don't wait until you are given a deportation order and then you're trying to file a removal. You're out of time. So try to file this when you are granted the resident status, between that and the time you are deported or removed from the United States. That's what they mean. So you have quite a broad time. So when you have, let's say you got married, and then well, let me say you got married and then 1 year later your husband is being really, or let's say your wife, who's a U.S. citizen person, is being really cruel to you as a foreigner. What you need to do is that even after 1 year, you can file to remove the conditions. You don't have to wait for 90 days before the expiration of the green card for you to end up dead. Okay, so these are exceptions. Okay, then the effect of not filing is that if this petition is not filed, you will automatically lose, of course, your permanent residency 2 years from the date on which you were granted conditional status. Okay, so what's happening is that, remember, when it comes to a regular green card, expiration of your card does not mean or does not equal expiration of your legal status. However, when it comes to the conditional green card, expiration of the conditional green card actually terminates your legal status. So if you're a green card holder, what gives you legal status is not the card. The card is simply documentary evidence. What gives you legal status is the status. The fact that you have been granted legal status and you have been, you are deemed to be a green card holder. So the card is just documentary evidence. So just note this: with a green card, the conditional green card, if it expires, your status ends with it if you do not file to remove the conditions, and then you become removable from the United States. Okay, so here's this special note, guys. If the petition is not filed, if your failure to file was through no fault of your own, then you can file a late petition with a written explanation and request that the U.S.A. excuse the late filing. This must be reasonably done and it must be reasonable. So failure to file before the expiration date may be excused if you demonstrate when you file the petition that the delay was due to extraordinary circumstances beyond your control and that the length of the delay was reasonable. Okay, so for example, let's say there was coronavirus and then you guys have been through a really, really rough patch. You were supposed to have filed, let's say your green card was expiring December 30th, so you had 90 days before December 30th. So let's say from October 1st, roughly. So you were supposed to have filed to remove the conditions, but you were hospitalized in September due to coronavirus, and you have been battling, with your health. You have been, just struggling for life. You've been on oxygen. You've had crazy medical issues. In such a situation, if you decide to file now, and let's say you have been on medication since January, you've been trying to regain and restore health, it's a reasonable excuse, and this was extraordinary circumstances. So you just simply need to get the assistance of a good immigration attorney so that you can file, and then demonstrate to the USCIS that, hey, I didn't just fail to file it. I had something, these were extraordinary circumstances beyond my control. Or, for example, you had ineffective assistance of counsel. You told your attorney, please, can you file this for me? And then he said, yes, he had filed it. And unbeknownst to you, he had not filed it. It wasn't your fault. But these things, the length of the delay must be reasonable. So if, for example, you were supposed to have filed within 90 days and you say that, hey, I actually delivered a baby maybe 2 days to the 90-day period, and then you are now filing this late petition 5 years when the baby is now 5 years, is almost an old man, is like running about and playing football. That is not a reasonable delay. But let's say you gave birth, the baby was, you gave birth two days to when the baby was delivered, and now the baby is 6 months. You had some challenges. That's reasonable, but you don't wait till your baby your baby is now like a 5-year-old grown man who can tell you to shut up and can eat all sorts of food and poo-poo on the adult potty, and then you're filing and say that, before the expiration I gave birth, and it's been 5 years. The length of the delay must be reasonable. Okay, so it's all a matter of fact. Just call me if you need assistance with trying to dissect all of these issues, because I've made it sound really simple, but it's not as simple as it sounds. All right, guys, I think that we will end it here, and then I will see you guys again hopefully tomorrow. We have Georgie Clotis says hello, and then Georgie Clotis says good to be here. Hello, thank you so much for joining. I'm so happy to have you here with me. I'm actually going to give you a call after this video. I really appreciate your presence. All right, guys, thank you so much for joining. If you need help with removing your conditions, the conditions from your green card, please call me on 802-7800-564. I serve clients all around the United States. I also handle all types of U.S. immigration law issues. So don't forget to call me, and I will be happy to assist you. All right, guys, be safe, stay blessed, and we will see you again soon. Take care. Bye.